Hello, everyone. This is Rajiv S. Khanna for immigration.com, the law offices of Rajiv S. Khanna PC. Last recording of October 16th conference call, community conference call, was corrupted because there was a power glitch uh, on the computer that I was working on, and I could not recover that file. So I'm redoing it. I thought most of the people who had questions had already attended the call and they had the answers. But Monica has been receiving phone calls about the recording. So I'm just going to redo it. It shouldn't take me long. First question is Christopher, who wanted to know about N400 for veterans. I'm sorry, Chris, I have no idea. I recommend that you speak with your congressman's office. Okay, contact them, and that should give you all the answers that you need. Um, Wife is a US citizen. I'm in Canada. In Jan, will be married 2 years. If she submits an application to sponsor, this is from Nick Dees, can we submit the 485? Well, first of all, Nick, you are in Canada. In order for you to submit 485, you have to be in the United States on a valid visa status. And you should not enter USA just to file 485. That would be considered to be a fraudulent entry. So it looks like you may want to go through um, consular processing rather than 485 process. Okay. If you're not clear about what that involves, go ahead and log in next time, and we'll talk more about it. Next question is Stu, and I have marked it as a frequently asked question. From It's about affidavit of support. My brother is a 22-year-old citizen still in college, filed to sponsor our parents, but what to do about financial support? So, first of all, can my parents self sponsor? There is a provision in law for use of some of the assets to support um, the ability of a person to, be financially responsible. So, there is something in law that does permit you. Correspond with the US consulate, okay? See what you can do. But the easiest thing is, of course, to get a co sponsor. And anybody can co sponsor. You don't have to worry about a relationship. As long as they are a green card holder or US citizen, they can sponsor. That is usually a good idea. So your brother would have to file an affidavit of support even though he cannot support them. That's fine. And then get a co-sponsor. In the meantime, correspond with the US consulate and see to what extent they allow you to use their own assets. Okay. Eric 83 got his green card in January 2010. Um, so his question is, for naturalization purposes, how do they count years or months of absence and presence? Is it by calendar year or is it by 12-month period? As far as I know, it is not by calendar year, it is by a 12-month period. Okay. I can't say that I definitively know this answer, but my understanding is that they use 12-month period method. So if you are gone for 7 months between March 1st, 2013 and March 2014, they go March to March instead of March to Jan and then Jan to March, as far as I know. But double check that. It should be on the USCIS frequently asked questions. If not, you can always call them and ask them. Okay, this is the kind of information they can give over the phone. Okay. Next question, non-immigrant change of status, travel while change of status pending. So Preeti is on H4, filed H1B. Um, and traveled out of the country while the change of status was pending. So what happens is if you travel outside USA while any change of status is pending, not extension, but let's say you applied for F1 to H1 or F1 to F1 to H4 or H1 to H4, H4 to H1, any change of status. If you travel, that change of status is deemed abandoned. Okay, so if you travel while the H1 is pending and you come back um, on a different status, let's just see, You were on H4, filed H1B this April, subject to cap, traveled out of the country March 15th to April 15th. So that means uh, you were outside USA when the H1 change of status was filed. Okay, that's what it looks like. You were on H4, filed H1B this April, subject to cap, and traveled out of the country from March 15th to April 15th. So it's obvious that you were outside USA when this change of status was filed. There can be no change of status if you're outside USA. And if even if it is there and you traveled, chances are this is considered to be an abandonment of the change of status request. So if you have received an H1 approval and the change of status is also approved, it's a mistake. You should apply for a change of status. And the other option is for you to apply for an H1 visa outside USA and come back using that H1 visa. That way you'll be back on H1. So you've got an H1 approval. You're exempt from the cap, but you are still in H4 status because you went outside USA and traveled back on H4. Next question, Raj IMG. Travel on advanced parole. Am I still on H1 or am I on EAD? Okay. The way it works is um, if you travel outside USA and you enter back using your advanced parole instead of H1 visa, but you're working for the same employer or in case the same two employers, you are still considered to be on H1B. Okay, so you are still on H1B. You don't have to amend your I-9 to say you are on EAD because you're still on H1. And you have the option now, if you want to change another employer, you can go on to EAD or you can apply for transfer of H1. Next question is May Planiappan. Filed my labor I-140 485 with company A. I-140 is approved. After 8 months, um, got a job with company B. May was actually there in the conference call when the where the recording crashed. So I remember talking with May. Did not file AC-21. Um, I have an offer from company C now. The green card is already approved. So the point here is a green card got approved when the AC-21 had not been filed. Is this going to be a problem? Should I be waiting 6 months? Um, can I communicate to USCIS that I've joined a new employer? In other words, can I do an AC-21 after the green card is approved? And the answer is no. There is no requirement under the law that you must inform USCIS that you have changed jobs on AC-21. Okay. But what I would recommend is that keep some documentation that shows the job that you transferred to was substantially similar or same to the job that was filed for the green card purposes, just in case this issue comes up during naturalization. It does not usually. USCIS is now well aware of the AC-21 requirements. There is no requirement that you must inform USCIS if you change jobs, but it's a good idea to keep it anyway. I don't think you have any trouble, and I don't think you need to wait for 6 months or anything. Okay. Um, Flying Machine says, I'm the beneficiary of an approved H1B, attended the visa interview, they handed a 221G. So the employer is a small company. How long will the 221G come back for it to come back? Nobody can predict that. If it comes back negative, will I be cap exempt? Well, you were in the US and you got a change of status. So I think you'll be cap exempt. Um, if you change jobs to another employer while this is going on, I think you'll be cap exempt. If, however, the petition is revoked, denied is not a problem, I think. You'll still be cap exempt because you got a change of status in the United States. So your H1 exemption is finalized. But if it gets revoked, will you still be subject to the cap? I think you'll be subject to the cap, but I'm not sure how USCIS looks at revoked cases. In my view, because revocation goes to an erroneous approval, so that means the approval that you got was a mistake, I think you'll be back to being subject to the cap. This part I'm not sure about, but if you change employers, you should be exempt from the cap. If the visa gets denied but the petition does not get revoked, you should also be exempt from the cap. Okay. So is it okay for you to find a new employer before the 221G results come out? Why not? I think it's fine. Is it true that working at a client's location has more preference over employer's location? Absolutely not. It's actually the other way around. If there is a solid in-house project, that is usually better than, at least for visa stamping, and even for H1 approval, than working at a client site. Next question is Mehak1234 came to USA on L2, got an EAD, currently working for an employer who got the H1 approved effective October 1st, 2014. It has not been stamped yet. Citizenship for Canada got approved. So, does the change of citizenship affect H1 status? I don't think so. You should be able to come back using your new Canadian passport and existing I-797. CBP will tell you if they need to see any changes in your 797, such as an amendment to reflect your change of citizenship. I don't think it should be a problem. Should I enter by revalidation of H1B on my existing passport? Look, I think India does not have a process in place for keeping two passports. USA does permit it. If India did permit it, you could very easily have used automatic visa revalidation, which allows you to use your I-94 to re-enter USA as long as your trip outside USA is less than 30 days. The fact that you changed to the citizenship of Canada should have no bearing on this matter. Okay. If I choose to enter my L2 visa, is this possible? Yes, of course. Does your EAD reactivate? I don't know the answer to that question. I don't think anybody does. You can ask USCIS what they feel, because technically, when you have an L2, you shouldn't really need an EAD. It's a part of the documentation rather than a part of eligibility. Um, L2 is employment incident to status. As soon as you have L2, you're allowed to work. But how do you document the I-9? For that, you need the EAD. Okay. So does the EAD get revived if you come back on L2 visa? I don't know if it does so automatically. Check with USCIS. I cannot answer that question. EB1, EB1C aspirant, so somebody who wants to do an international manager petition, was with a small company as a senior project manager in March 2010. Traveled to US on business for 4 months. Took a position in March 2011. Well, first of all, you have to have at least 1 year outside the US. Okay. 1 year outside the US. I don't know if you have that. Full 1 year. In fact, I would say 366 days. That'll be a good idea. Second problem I have with your case is that a project manager may not necessarily be a managerial level employee, because the way USCIS defines manager or executive for EB1C cases, they don't want you to be primarily involved with the activity of the company. So if the company is providing consulting company, you shouldn't be doing the consulting yourself. If you are managing the consulting rather than doing it yourself primarily, you have a chance. So when in doubt, because EB1C has such good benefit being so quick, I would say always apply. Next question is from S.A. Mathur at Yahoo. Citizenship if I move to India after getting green card. I have a green card for the last 3 years. Plan to move to India and keep coming back to US within 6 months. Look, if you move your home from USA to India, your green card can be taken away. So naturalization is the least of your problems. First thing is how to preserve your green card. If you leave USA, they can take away your green card. Just maintaining a house is not good enough. Your permanent home must be in USA. Technically, even if you leave USA for 1 day with the intention of never coming back, but you come back 1 day later, technically you've lost your green card. They can go after it. Okay? So don't depend upon that. Don't depend upon that. Up till you have complete naturalization, your permanent home must be in the United States. Next question is Robin. I am a Canadian on F1 status, about to graduate with my MBA. So wants to go to TN. Should I still go through OPT or should I apply directly for TN? Do I need to return to Canada and cross border to obtain my TN, or can I obtain from within USA? And also I'm getting married to a US citizen. Okay, well, if you are getting married to a US citizen, I think the easiest thing for you to do is to stick with the OPT process. Couple of things that I like about OPT for you. One, it is quite pain-free. It does not require a whole lot of petition. TNs you still need to apply, and you can apply within USA. You don't have to go outside USA. You can do a change of status to TN. But OPT is much better in my opinion, especially if you have a job in your own field. And you don't need it for a long time anyway because you're getting married next year to a US citizen. Okay. So I think the better thing, Robin, is to just stick with OPT. And when you apply for your green card after marriage, in 90 days you'll get your EAD to continue working, and then you get your green card. Okay. Dhruv says, I have a question about I-140. I am on 7th year of H-1B, approved I-140 with the present employer. The new employer would start PERM application after 1 year when I change jobs. If PERM gets denied, then I have to leave USA. If previous employer doesn't revoke the I-140, then can it be used by new employer to extend H-1? Yes, it can be. It is not required that I-140 be approved with a particular employer for that employer to get an H-1. Any approved I-140, as long as it is not revoked, becomes grounds for extension of H-1 through any other employer through. Okay. Next question is MacPass. My employer will soon file I-140 and 485 concurrently for me. I'm in EB2 with the rest of the world. Current priority date. Is the process of I-485 dependent on the result of I-140? So what he's asking me, should I file I-140 premium processing? And the answer is yes, because I don't think they process I-485 until the I-140 is approved, as far as I know. So really, if you want to have a quicker adjudication timeline, you should do premium for I-140 and I-140. 485 will automatically get faster. If I reach 6 years on H-1B, will I have enough time to get my green card until then? Well, you can do an H-1 extension beyond 6 years. That is not a problem because you qualify. Your PERM was filed more than 1 year ago, so you'll be fine. I don't see any problem with that aspect. Milan Alonso and I talked. He was in the conference call, and I had asked him, Milan, just send me an email to help@immigration.com. Your question requires a lot of discussion. So what we should do is set aside some time for us to talk. We'll record the call and make that available as a frequently asked question. Okay. Next question, Sridhar Kunjeti. I came to USA on F1 visa in 2006, graduated in 2011 with a PhD degree, working as a postdoc with DuPont. Worked on OPT for 1 year, company filed H1. Postdoc is ending December 2014. So if I go from a CAP exempt employer, from a CAP employer, which is a private employer, to an H1 in the university, can I transfer the existing H1? Absolutely. No problem at all. So you can go from private H1 to university H1, no problem. Later on, if I want to come back on to private industry, am I subject to the cap? And the answer is, I don't think so. My guess is, again, I don't have any definitive answer on this. My guess is that you will not be subject to the cap. Because if you look at the language of the statute, all it says is in order for you to be exempt from the H1 quota, you must have an H1 approval within the last 6 years. And I think you qualify under that. That's my interpretation. Fatima is an F1 student for the last 9 years, and she was there on the conference call, so I remember talking with her. Her parents had applied for a tourist visa, and the consulate denied, saying you didn't return to your country, so you're illegal. And I had told her, don't let it slide. Don't let it slide. Make sure you fight it because that's a negative interpretation, and it's really not true. So make sure you fight it out. And I did guide you. You were in the conference call. Next question is Drew, eligible for citizenship on December 29th, taking advantage of 90-day rule. I've been working as a contractor for the last 2 years. I've opened my own company. He wanted to know in the column on N400, how should he present his self-employment? And we had talked about that. Andrew was also there in the call, and I had indicated to him that's really not a very big deal. You can put anything, you can put your title, you can put self-employed, it doesn't really matter. Next question is Geo 2008. I-140 was approved in EB-1B category. Um, so first question was, so he's outstanding researcher or professor. First question was, I-485 approval time is about 6 to 9 months. Do you think there is a possibility that this process could be done faster? Yes, there's always a possibility. While I-485 is pending, can one get salary raise and title change? Look, as long as I think you were there as well, if I remember correctly, and I had told you that try to keep the same job, okay? But if the job is substantially similar, you can certainly argue that it's the same job, okay? I just don't like the idea of changing anything, and I'm not even sure if AC21 applies to EB1B. You'll have to double check that. I think it does because AC21, as I recall, applies to all employment based cases, including EB1C. So it should apply to EB1B, double check it. But in my view, until the green card is actually approved, it is probably better to stick with the same job. Okay, let's go on to the. I thought there were more questions than that. Oh, yes, there are. There's a second page. Here we go. Okay, then Shankar ZX. I'm on H1, ninth year. My company is being acquired by another company. The buyer company is not interested in sponsoring H1. Another employer, a new employer, wants to do an H1. What happens if the buyer company revokes my I-140? You will lose your right for H1 extensions. You'll keep your priority date, but H1 extensions you won't be able to do. My new employer is willing to sponsor my green card for a different position. Can I port my priority date? Oh, absolutely. You can port your priority date uh, because of the I-140 approval across categories, across jobs, across employers. Totally different job is no problem. Okay. So, and I told you that there's no need to return to India. You can port your priority date to a completely different skill, completely different title, no problem at all. Raj, IMG, one more question. I-485 was filed on July 1st, 2014. Technically, the PD is still current till November 1st. Yes, the way it works is around 15th or so of every month, the priority dates are announced in the visa bulletin for the following month. So, October 15th, you get the visa bulletin for November, and those priority dates will stay current from November 1st to the last date of November, all through the month. Abhijit wants to know green card through marriage if spouses live away because of personal work reasons. And I said, Abhi, it is not a problem. We've had many, many cases where spouses are living away from each other because of work or personal reasons. As long as the reasons are genuine and the marriage is genuine, filing for a green card is a very good idea and it goes through. There may be questions asked, but that's okay. Um, So USC C after GC wants to know, got green card through consular processing, and he was also on the call. He was also on the conference call. What happened was he got his green card through consular processing, came to USA, has been working with this company for 1 month, and they haven't paid him. So he wanted to know, can I move away? Will I lose my green card? And the answer is, you will not lose your green card because you've done the best you could. You've emailed them about your salary. You worked there. And I told him that the safest thing to do is to complain to the local Department of Labor. For example, if you're in California, complain to the California Department of Labor, not federal, and say they haven't paid my salary, I've worked. What that does is that protects your green card. Even if you don't get your salary, I think you'll get your salary. Um, the fact that you complained and documented it protects your green card. And otherwise, it can become an issue at the naturalization stage. Kavita had another frequently asked question, B1 or B2 visa extension issues. So, wants to do a B2 extension for 3 months for her mom. And I think she was also there in the conference call and we talked. Is it permissible for her to stay in the US beyond the original I-94 while she awaits for the extension? And the answer is yes, she can. It is this kind of status where you timely file for an extension is called authorized period of stay. So if the I-94 expires tomorrow, but USCIS received the extension request today, And from day after tomorrow, your mother will be in authorized period of stay. She can stay for up to 3 months while she's waiting, whatever time she's asked for. She can wait for the decision. But make sure you keep a copy of the application in case she has to leave before the application is decided. So that tomorrow when she comes back or goes for visa stamping, she has proof that she did not stay illegally. In fact, she was staying under authorized period of stay because she had filed a timely application. So keep the proof of the application and the proof of timely delivery to USCIS. Okay. Also bear in mind, USCIS does not like too many extensions. If you live here more than you live in your own home country, CBP may not let you enter USCIS next time if you come back too quickly. Also, if you spend too much time in USA, getting future visas may be difficult. Okay. Next question is change in job title from Atul, AP Dhule. Change in job title description while perm-based green card is pending. Not a good idea. If you go from one title to another while a perm-based green card is pending, like you are going from an engineer to a technology manager, I think you should file perm again. You should get started again. You can carry the priority date, of course, if the I-140 has been approved in the previous case. But you should not take the risk of not filing again. Okay, folks, I had to rush through these questions because I'm in the middle of the workday, but I know some of the people who had posted are waiting for these answers. So I wanted to do this real quickly. Um, we can talk again. I will not be doing the next community conference call. I have something scheduled for that Thursday, but we'll be back on this on schedule after the next Thursday. I will be doing it every 2 weeks, like we do normally every other Thursday. Good talking with all of you. Thank you for listening to this call, and I hope to talk to you soon. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202 800 8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.